Hello, good night. Happy New Year to all those following this program. And welcome to the start of the second year of Legalize. Welcome to our guests. This year, we want to build on what we achieved in the first year. We want to continue to provide good content, but we have added some features to add value to the program. There is now a calling feature, which would allow followers to participate so that the program will be more interactive. In addition to myself, there will be a co-host. Tonight's co-host is Mr. Simeon Collins. In subsequent programs, before we engage the guests, there will be brief discussions between Mr. Collins and myself, host and co-host. We also intend during this year to post short informative videos on the YouTube channel, starting with issues such as wills, intestacy, mortgages. In this way, we hope to build up subscription to the YouTube channel. The program, we continue to have sponsorship from Gel Professional Solutions, from Gem FM carrying this program on the station in Canada, and also GTAM. And we want to thank and recognize GTAM.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Our guests tonight are Ruggles Ferguson KC, well-known Grenadian and Caribbean attorney. Bert Paterson, the General Secretary of the largest trade union in Grenada, I think. And we also expect to have Dr. Curlan Gilchrist, who will be on audio. Tonight's discussion is, as was advertised, on the new pension bill for public sector employees. And we have, as I said, we have persons, an attorney, who will look at this issue from the standpoint of the law, a trade unionist, who of course will look at it from the standpoint of the employees, and we expect Dr. Gilchrist, who will look at it from a broader perspective. Dr. Gilchrist, in fact, was the chairperson of the committee that made the recommendations with regard to the pension bill. So, welcome, Bert.
Thank you.
Welcome, Ruggles.
Hi, thank you, and Happy New Year to listeners. Though we are in advanced stage of January as the first program. Happy New Year to my colleagues on the program and also to the listening and viewing public out there.
Yes, so, and of course, welcome once again to my co-host.
Thank you, and Merry New Year to everyone.
Yes.
Okay,
I must
good.
say you have a very good co-host tonight. Only yesterday I saw him and was commending him on the consistent work he has been doing in the field of public education with the articles, the various very interesting articles in the newspapers every week. And, I hope that others will follow his example. And here I am seeing him on the program tonight. It was only yesterday I was commending him. So
Yes.
keep it up, Simeon. Yes. Uh-huh.
Well, it's all about giving back to the community that gave us our education and gave us the equipped us with the ability to gather the knowledge and so on. It's only fair that we share that with the community that has really cared for us and nurtured us. And I know Simeon is in that spirit because the institution we went to, they teach us about our vocation. And obviously, our vocation is sharing our information with the public. And we really welcome
that's Presentation Brothers College. Actually, 78 years old today. I'm on the 25th. It was 78 years old.
Yes.
Presentation
And
Brothers.
just give me 1 second, please. Curlan?
And just to say that PBC has had 4 prime ministers so far in Grenada: the president, Prime Minister Dick Mitchell, the past one, Dr. Keith Mitchell. During the revolution, the prime minister, that was Comrade Maurice Bishop. And then also George Brison was a PBC boy. So we had a number of them. Ulysses Whiteman was also PBC. Kenrick Radix, just you name them, they were all PBC. But
yes. Well, keep up the great work. Congratulations, and keep up the great work because this is so important. Programs like these are so important in terms of lifting the debate, the national debate, and taking the debate particularly outside of the narrow political confines. Too often we have these debates confined to narrow partisan politics. And I think programs like these assist to give people a sense of focus on the real issues, that confront us, and understanding the act itself, and its pros and cons. Mm-hmm.
Yes, indeed. We just give us a second for Curlan to join.
Right, and just let me ask: are you hearing me clearly?
Yes, I'm hearing you clearly.
Okay. Yes. All right. Good.
Yes. I just want to mention that on the 9th of February, we will have an attorney from the US, immigration law specialist, in fact, who has agreed to share his expertise in the context of the recent immigration executive orders by the new president in the United States, and he will speak about them and also how they are likely to impact Caribbean people. So that's a program to look out for, and I'm certain it will be quite useful. We'll send out the flyer for that program maybe in the next week or so. I think Curlan is here with us. Yes, Curlan will be on audio only. Good night, Dr. Gilchrist.
Good night, and it's a pleasure to be part of this this learned and team. I feel honored and I'm humbled, to be on the program.
Okay, we thank you so much for coming on. And I mentioned you would not have heard that there's a calling facility. So later in the program we may receive 1 or 2 calls, and I'm certain some of the calls will require your intervention with your unique perspective. So I don't know if we could start with Bert in terms of the act, because that has been in the works for a while. I think there was a bit of controversy. The act is now on, so it is what it is. So I don't know if we could start with you to get your comment on it.
Good night again, everyone. Well, the act itself and how it has come about is probably one of the matters that we do have some issues with, and I'm talking from a labor perspective. It is clear that the act changes working conditions of the workers involved, and to include workers having to dish out and pay from their pockets in order to get benefits. In the past, this would have been something that would normally be negotiated. This, I believe, at least for Grenada, might be the first time when working conditions to specific employees are changed, not by negotiations, but in fact by an act of parliament, which is somewhat different to what has happened in the past. In our discussion, the example of NIS came up, but NIS is slightly different because NIS made changes for all workers of the state, not for particular bargaining units, but NIS made changes for all workers, which NIS, some people view it almost similar to taxes, and that is the paying part of it, not the receiving part of it. So all workers had this change in the island, and therefore I don't think it would have brought about this same thought or discussion as in this case, where in this case there is even record of items like this being negotiated, it being appearing in several individual collective agreements, which in some cases now we are looking to see if null and void, or to see the effects of this change to the workers' condition, which was not negotiated but went through as an act of parliament. So that will be the first observation I would want to make. I'm glad Brother Ruggles is here, because my appearing here tonight might be more looking for advice and information than having definite positions on items. So I don't think we have to pay Ruggles for that. I don't have to pay Ruggles. And Mr. Gilchrist, Dr. Gilchrist might also be able to assist us in that way from labor. One thing I would really like to point out is that in looking at the matter, we did look at the differences between this legislation and the NIS legislation, which is there are vast differences. No, both are supposed to be for the same thing, workers' pension. NIS goes a little further because it does do sick leave and other conditions, other benefits. But I may have expected that the law would look and read like the NIS legislation, where everything is spelled out. I can't say the same for this act, and maybe if we have the time, we could probably go through some of the differences between the act that has just been passed and the NIS, and there are some pretty hefty differences, right? Just probably to mention two at this point, right? Whereas the NIS is operated based on its director structure or its board structure, literally independent of government, in that the government chooses two directors, the employers, and that would be private sector employers, chooses two, labor chooses two. It is a tripartite arrangement and managed in a tripartite way. The other member on the board is an employee of the NIS, right, which also gives it some balance. In this case, the minister, and let me not say the government, chooses 8 of the board members, and one is chosen or suggested by the workers. So there's obviously not any balance there. You have to probably look at it as a government department. Added to that, whereas under the NIS, government cannot borrow up to a certain amount of the monies that are kept in the fund. In this case, there is no limit to how much government can borrow from the fund. That is important because when we look at some of the NIS operations outside of Grenada in the Caribbean, most of them are literally burst, including Barbados, including Antigua, in a lot of cases because of government borrowing. So I'll just start with those two, which I would consider probably two of the major differences. And I won't go in too much now on how it's affecting workers and what should have been done before, after, etc. But it's just an observation that the act is very, very different, including that it's a defined contribution and not a defined benefit. So technically, this is an insurance and endowment kind of plan. I would leave it there for now.
Okay. Curlan, you want to come in, or Ruggles, you want to come in? Because I just want us to go back to
Yeah, go ahead, Curlan. Yeah.
Yes, I just want to say that well, first of all, I want to refer to Bert's comment on the differences between the two. He's correct that the employer in this case establish a pension scheme, and NS is much more than pension, right? And secondly, the new Pension Act is really a top up to what is to the pension that is being offered by NS. So it's a top up. So more or less what happening just a continuation to the previous government initiative, right? Where they were looking to come up with an arrangement that would top up what is being offered by NS for pension. No, no. So that's the approach that was taken, and therefore, um, the way it was done, it's a pension, and therefore a pension when calculated and when administered and when applied should allow one to get a reasonable um, sum of money that would help one maintain one to an extent one quality of life on retirement. That's the concept. So it's and pensions have their own commonality and their own features and so on. And therefore, I understand the comment with respect to no consultation on the rate itself, where we are 3% and 6%. But the reality is that in designing that pension scheme, one has to do the calculation to make sure that what is being asked is realistic and makes sense and can actually be when added to NIS would help one not to live in poverty on retirement. So that part of the arrangement was actually calculated based on actual reviews. And I must say that we use the same actual scientists that NS usually uses. So that was a calculation because it's an insurance product, right? And with that insurance product, you got to cost it and come with a premium. So in a sense, if you go to negotiation, it will be based on costing. And I would say you may get the outcome may not be different. But I understand the point. But I also see it is an insurance product and it's all based on costs and what are the expected outcome. Now, of course, you could say you charge a lower rate, but if you are charged a lower rate based on a calculation, um, the addition to what you get from NS would not really make a big difference. So we wanted something that would make a difference. So when you add the retirement benefit from the new pension scheme to what you get from NS together combined, you get on retirement you get at least 80% of your income, right? About 80% or so on. So that's the rationale for the way it was done. I don't know if we had the same because I gave leadership to the process. I don't know if we had say consulted the union on the rate itself, if the outcome would have been different because whatever discussion we would have had would have been based on scientific evidence and actual data. All right. So I just want to comment on that part of it. The other part with respect to the way the governance structure is set up. Mr. Layne, I don't know if you have the act you could put the act on the screen because at that point I think while the minister appoint is on recommendation. Yeah.
Let me see if I can put it on the screen.
Yeah.
But I can just read from it still because
yeah, read from it. Yeah, that point.
Yeah, you talk about the part 4, establishment of the board of trustees.
Yeah.
All right. So the relevant section, I think the important subsection would be the board shall consist of the following persons appointed as trustees by the Governor General, acting on the advice of the minister.
Yeah.
A, the permanent secretary with responsibility for public administration or his or her designate. B, the permanent secretary with responsibility for finance or his or her designate, who shall be ex officio members. And the following other persons: an attorney at law who has been practicing at the bar for at least 10 years, an actuary or a person with actuarial qualifications or experience, one person who has demonstrated knowledge and experience in finance, one person who has at least 5 years of experience in human resource management, one person who has demonstrated knowledge and experience in investment, one person after consultation with the trade unions representing public sector employees, and one person after consultation with the statutory bodies. So those are the trustees. So you're talking about 7 persons. And I think what Mr. Paterson is saying is that only one of the persons would the trade unions have an input in considering. In fact, you're talking about 9 persons. You have 2 ex officio members, meaning by virtue of the office. Whoever holds those office, they are members. And then you have 7 others. So I think that's the point he was making.
Okay, I get a point, and I suppose I anticipate that the minister, in exercising those responsibilities, will consult the relevant bodies. Yeah, he didn't say that, but I want to make that assumption.
Yeah, but I think he's comparing it with the NIS Act, which is very explicit in terms of the process. Yeah.
Yeah. I take the point. That's a good point. Yeah.
I don't know, Dr. Gilchrist, is there any reason that any explanation as to why the approach in terms of setting up a new architecture, a completely new structure was taken rather than utilize what we already have, namely the NIS?
Yeah, that's a good question, and I remember our first consultation was with the Chamber of Commerce, right?
Mm-hmm.
And with respect to the management of the pension, that was put out to consultation, and we also asked whether or not NS should be approached, and we never got support. Right, that it should be put to NS. We never got that support. That never came out of the consultation. There was no favorable response, right, on that, and that's one of the reasons why the government moved to set up its own structure. All right, but NS itself was going through institutional strengthening and all that stuff, right? But I don't know what will happen in the future, but that question of having NS manage the pension was put to consultation, and we never got any support coming out of the consultation for that. And these are the facts.
And just to put a little context, prior to NIS, what percentage of the last salary, the maximum with a government pensionable government officer, public officer, what percentage would they have received as a pension?
Well, under the 1958 pension, right?
Yeah.
If you retire out of that pension, your pension would be approximately half your last salary. Approximately half your last salary. Right? That's the pension plus the gratuity, which is a lump sum. So you get a lump sum plus half your pension. Now, with NIS now, if you retire and your only source of pension is NIS, the most you can get is 60%, right, of the pensionable amount in NIS, which is just about $3,000. That's the most you could get. The new pension scheme is adding approximately about 22% to that 60%. That brings it up to about 80%. So you just have top up. You just have top up to NS. Yeah.
Yeah. I think actually under the 58 pension scheme, the maximum pension which you would have achieved after 26 years and 8 months of service was 2/3 of your last salary.
Yeah.
That would be the maximum pension.
As a maximum.
The other system you can get 25% of your pension for 12 and a half years. You got it as gratuity.
Yeah.
So I'm just putting it in context because I asked the question because I don't know if I'm correct, because the figures you gave, the NIS pension, there's a maximum, there's
A ceiling, yeah, of
there's a
5,000.
ceiling of 5,000, right?
Yeah.
But you say that when you add the government, the pension under the new pension scheme to the NIS pension, your data is that your figures is that employee may be going home as a pension with about 80 to 85% of the last salary.
Yeah.
Okay.
If I may,
Sorry. Yeah.
Brother
Yes,
Layne,
but yeah.
just to one of the issues, and which is why we didn't delve into the question of whether the contributions are too low, too high, as yet, because to us that is not the major issue, because the unions have been calling for additional pension for workers who don't have as yet, in particularly government workers, right? So, but it is more the how it is to be operated, managed, etc. So, for example, why I said it was one of the more important things, the government now will choose the 7 members of that team, and there may be actuaries, there may be lawyers, there may be whatever, but the government chooses them. No, and I'm very political in speech, not in action, but in speech. So let us say I am an NDC, and my government is in power now. My fear will be when NNP gets in, and that minister is of a different sort of person, and that government views things in different ways. The lawyer they may choose, or the actuary they may choose, or the professionals they may choose, may have particular leanings. And it has happened in the past, because we've had several boards in the past chosen by ministers who have given away, sold, stole, and all that from the public purse. That's just a fact of life. So I'm really wondering how it was that when this was being envisioned, how those thoughts didn't come up, that it might not be my government in the rush, but it might be another government which may not be as trustworthy as this one. So I'm saying I'm saying this vice versa, right? So something like this, which interferes with my money. When I say my money, because if I go to work for 40 years at either the 6% or the 3%, it could come up to $300,000 that I would have to pay into this arrangement over the next 40 or 42 years. Or in the case of the 3%, based on and I'm not looking at inflation and all that. If I were working for $3,000 a month, no, how much I would pay into that fund over the period would be, it's not small money, it's big money. And it is not money, it's workers' money that shouldn't be played with. But the legislation allows it to be played with, which
Okay,
is
so
that's the issue I was making.
okay, so your concern is that there are not sufficient safeguards. It has nothing to do with the current government, but this is a continuing structure, so you don't know whose hand it will fall into. And we have had experiences in the Caribbean, some quite recent, where workers have lost their, well, all the years of all the savings. So that's your concern.
That's my concern, and it continues in that trend, but we may not have the time to go into all.
But I just want to jump in here. I understand the concern, and but if you look at the act, There are safeguards in the Act to mitigate against such things happening. You look at the continuous actual reviews and auditing, and also with respect to the point on politics, I get that point, but those members to be appointed are technical and professional people. All right, and they have to function by prudential and corporate rules and guidelines. Of course there are risks because you are receiving money and you are the custodian of those monies and you have to invest it to get a return. Yeah, and that's the part where the government is hoping that they would have a competent authority or a competent body to manage the fund, because it has to be managed properly. We know what happened in the Caribbean with investment funds and so on. So it has to be managed, and it's a cost of administration. So I'm saying that that the operation of the fund will be carefully managed. I am hoping that they are competent people, whether it doesn't matter your political opinion or leaning, but competence is important, all right, to guarantee that the funds will be managed properly. And I think if we stick to that competence and expertise, I am hoping that the funds would not be derailed or go bankrupt.
Let me ask, no, any consideration was given to having the government on the truly consolidated fund guarantee these funds?
That point was raised. That point will be, we did give consideration to having some mechanism included in the Act that would kind of guarantee a minimum pension. Yeah, because remember, it's an investment of funds, right? And investment returns can be positive and negative. So in other words, the funds can deplete as well as it can increase. It's management, and that's a risk. Yeah. So the point was raised whether or not there will be some minimum guaranteed pension. That was discussed, and that is something that we could maybe can be looked at going forward. Yeah. In that, notwithstanding the returns, the government will guarantee a minimum pension. That was discussed, but we didn't get that into the legislation, and that is something to look forward to.
Yeah, maybe with some view to improving the legislation in the future as we go along.
Yeah.
Ruggles, I know there have been two issues, at least two issues. One, I know there is an issue that section, I think it is section 3 of the Act, which sets out who are the persons affected or by this Act, who are the scope and application of the Act. And that it says who are the persons that will be fall under this new legislation. All new public sector employees. So in other words, any person employed with the government of Grenada, as I understand it, from the 1st of January this year onwards, they will be subject to this Act. And it also says all public sector employees who hold non-pensionable offices by virtue of a relevant enactment or have neither attained the age of 50 nor have been employed with the government for a period exceeding 15 years and are not eligible to receive a pension, gratuity, or other allowance in accordance with the relevant legislation. And it says all employees of the government who are currently employed in the public sector on a contractual basis and by virtue of the terms and conditions of the contract are not eligible to receive a gratuity. That's who the act applied to. So the issue, I think, really is that, as we know, there are many people who have been working with the government in sometimes for long periods on so-called contracts. Yeah. And I think there was a thinking that all such persons, in fact, should be eligible for pension under the what is often referred to as the 1958 Pension Act. But I think this legislation is essentially saying, without directly and say so, that they are disqualified from that 1958 pension, and they are only eligible even if they were on contract, let's say for the last 10 years. Even in those circumstances, the eligibility to pension is only under this act. I don't know if you want to comment on that. And also, during the discussion tonight, I know there's a vexing issue regarding what the Constitution says on the matter of pension, which I hope we could just look at it.
Yeah. Okay. Thanks. If I may, just before coming to that question, and before probably we lose the point, because Bert and Curlan addressed it, and that's the issue of the NIS pension versus this pension. If I could just make a comment on that, just first and foremost, and then I'll come to the Constitution point and probably the contract point after, because the one of the striking issues in relation to the act is that we have basically we have an NIS, and the NIS was established in 1983, April 4th, 1983. NIS is now 41 years old. It's an institution that has survived for decades and continues to grow. NIS basically deals with social security, the age benefit of pensions, and they deal with other kinds of benefits like sickness benefits, invalidity benefits, and so. And when NIS was set up in 1983, the idea then was to expand the pension base in Grenada to include not just public workers, but to include all workers across the board. And it was a contributory scheme. So come April 4th, 1983, people who were in the service and got a 1958 pension, to put it simply, who, if you join the service on April 3rd, for example, you get a 1958 pension. And then after April 4th, 1983, you join on April 5th, 1983, you get an NIS pension, and everybody gets a pension. But within that structure of NIS, it was recognized back then, more than 40 years ago, that public workers were already getting a pension. And there was a mechanism created under the NIS Act to have basically a special fund, a special pension with regard to public workers. So one, expansion of the base of pensions to include everybody, private and public sector. And two, in recognition of the fact that public workers already got a pension, to have a special pension scheme. And that's where Section 47 of the Act is relevant. Now, fast forward, in relation to this fund, you have now a special public public sector fund being created, and it's a contributory scheme. Now, I've heard the comments and, well, rational. I can't say I'm persuaded yet, but why is it? And that was the first question asked. Why is it where you have NIS that has 40 plus years of experience in this area, has an infrastructure that is already deducting pensions back since 1983, has the technological support, has the investment experience, has investment committees, and Curlan raised the point about the management and investment of the fund. Would it not have been better to expand NIS, and you can create regulations and I think that is what Bert was probably alluding to with the specifics of NIS. That can be created through regulations, amend the act, because what you have in practice happening is the same deductions being made, So NIS is making deductions now, and this new board is also making deductions specifically in relation to public sector employees. But there is a cost. There is a cost associated with the management of these pension funds. And Grenada is a relatively small country, just over 100,000 people. And when you're talking investment, numbers matter. So, for example, if we're talking about bringing an additional 4,000 people onto the NIS system, that can only grow NIS itself, was performed commendably and creditably over the years, and you have the necessary amendments to the NIS Act in order to do so. Because right now, you would need, there's a director under the scheme, you have a deputy director, same as NIS, director, deputy director. You need staff in order to administer the fund. You need an investment committee. You need the technological base in order to deduct these monies. And so you have operating expenses can be fairly significant for the administering of the fund, one. And secondly, in relation to investment itself, because you might have investment managers. You say you invest this into a particular entity, and there may be a cost factor for managing it. So one of the concerns, and I'm not pronouncing on right or wrong here, but the discussion started off in that vein, and that's why I wanted to weigh in on it. Because really, if there was some consultation with the chamber, and really and truly, has the thought really gone into this? Because essentially what you have is a parallel NIS for a certain section of the public sector employees. And the cost benefit factor here, I think it is something that needs to be studied. And because with that expansion, NIS can grow. NIS, for example, has acquired its building, has its own building, its own infrastructure after all these years. You're talking about this entity going to rent, presumably, as a starting point, employ staff. So I'm just throwing that out. I'm not making a pronouncement, but it's really the first thing that struck me about this act. Whether or not it's a parallel NIS, and whether or not there should have been the repealing of Section 47 of the NIS Act, as opposed to strengthening NIS to manage this whole fund.
All
So
right. So,
yes,
well, I guess Dr. Gilchrist could tell us if that was, because I expect that some form of study and look at the figures involved would have taken place. Not so, Dr. Gilchrist?
Yes, that was that consideration. As I said it from the very beginning, that issue was raised with NS, and we did look at it. Yeah.
Okay. What
I find NIS sound so convincing.
Yeah,
Let
but
me
remember, I just want to tell you,
I hear the yes, but I find it sound so convincing at all.
no, but
Because
Well, let me ask so, Dr. Gilchrist. I know you know the old adage, you don't put all your eggs in one basket. Was
yeah,
that at work there? Was that
no, but in all seriousness, we remember too. I take the point about increasing volume, all right, with respect to funds. But remember too, Ruggles, that NS right now have his own solvency issue, all right, and the government had to make substantial amendments and introduce measures to fix NS. So while I take the point, NS has
okay?
been over 40 years, it has its own solvency issues, and they had to
Okay.
address that. So I believe that one of the reasons why maybe no active consideration was given to considering NS, notwithstanding we didn't get support from the private sector for the initiative. We did not get support, right? It's to set up something separate and distinct. But I take the point up with the cost. Yeah, it will be a cost. And of course, the government would have to bear the cost of administration for a while until the pension fund is able to handle itself. Yeah.
Okay.
Sorry, but if I may just comment quickly on that. One of the vagrancies of the act is that I'm not sure from reading it. It does suggest that management of the fund, direct management of the fund, has to be by an external party, not directly the board. Right? I'm assuming there's a suggestion that we would have to get an insurance company or a fund man, someone in that field to manage it. And it's not clear in the legislation. And secondly, whereas in NIS, administrative cost is by regulation. So you can't go, I think it's 12% above the size of the fund. It's a technical formula, but you can't spend more than a certain amount to administrate the fund, right? And NIS record is that they're about half of what is the regulation. In this case, I've seen nothing like that. And it seems that private entities may be managing this fund. But again, it's not at all clear in the legislation. I'm not sure if it's through hurry or oversight, but that is one of the major issues that we would have.
Yes, and I suppose the regulation would have to take care of that because of course you have to have guidelines for the management of the fund. So in the regulation, you would have to have guidelines with costs. Because if the fund get very inefficient, the workers wouldn't get anything. You know? So it can't be inefficient. You got to have a return, and that has to be monitored and managed. And there must be guidelines, right, in the regulation to deal with that. Yeah. So you have a point there. We have to watch that. Yeah. Otherwise, we're shooting ourselves in the foot. But Mr. Ruggles, but NS itself, I know you gave the historical thing with NS, but NS has its own issue with solvency, and the government had to address that, and they are continuing to address that with addressing the rates and the pensionable age and all of that.
Yeah, by increasing.
as you know, Grenadians are living longer, right? So that means people will be there taking from the fund, right? So all those demographic issues now have to be calibrated into making NS solvency and be able to
Yes.
sustain itself. And here we have a new public sector pension fund. I think hence the rationale, one of the rationale for having a separate entity. But let's see what happens in
Yes.
the future.
Yes, yes. Well, my passing words on that is to, I think it needs to be looked at, because the operating cost, sometimes that hidden cost, that factor is not taken into consideration because a relatively small fund. It's a relatively small fund, and you have a specialized unit dealing with it. NIS deals with everybody, and maybe the solvency issues with NIS was created as a result of NIS having to come to the rescue on several occasions in the past, and spending money that probably ought not to have been spent. But
Which
but
which
that's
is which is
another.
which is which is Bert's concern, or at least one of his concerns with
Right.
this
Yes.
fund, because he's saying that even NS has those problems, even with built-in independence
Mhm.
factors in terms of how people are selected. But he's saying now that you don't have that because it's a minister. You're not pointing at any minister. This is a continuing thing. You don't know who will be the minister 10 years from now. You don't know who will be the government 10 years from now. So I think that's one of the concerns. But Rosie, if we could go to the
Yes.
point about those issues.
Right. So
And there's a question here which may focus your mind
Mhm.
on this. I'm trying to see the question. What is the difference between a appointed public officer and a government employee, or is a public officer de facto? I think you can address the issues by keeping this question in mind also.
Right. Okay. Yes. So if we can look at the Constitution first, because that is what where everything springs from as the supreme law. You had first and foremost pensions for public officers under the 1958 laws, and it was not for all public officers or all employees of the government. You have established worker, just to put it broadly, the established worker, and you have the non-established worker. Those who are entitled to pensions under the 58 laws were the established, those were in established positions within the public service. Fast forward to 1974, when Grenada gained independence, and you had the 1974 Constitution, and there was the protection of pensions for public officers. In fact, the sections of the Constitution that impact on pension, you have Section 84.8 of the Constitution, which is a very unique section of the Constitution when you compare it with other constitutions in the Commonwealth. I think Grenada probably is the only constitution with that particular feature, and it has to do with the history of independence in Grenada and the turmoil that preceded independence in Grenada, and the need it was felt to protect, give extra protection to public officers. So you have Section 84.8. You have Section 92.
84 basically says what?
Yes. 84.8 deals with public officers whose department is reorganized or whose positions are abolished in the service, and they are treated under 84.8 as persons who, when are retiring, you have to retire them because you abolish their posts, or you're reorganizing the department. So that is not, we're not dealing with 60 years retirement age here. You're dealing with somebody after 10 years going home. And you are saying under those circumstances, that person has to be treated as though he or she had attained the age of 60 years. In other words, your payment of pension has to be looked at not on the basis of 10 years service or 15 years service or 26 and a third year service, but on the basis that your position has been abolished and you are treated, insofar as pensions are concerned, with as though you had attained the age of 60 years. And so that's
So-
section 84.8.
Also, in short, we can say that was put in there to that was put in there to as a safeguard against the fear that the government might just dismiss its opponents,
Precisely.
send
Yes.
them in the ground heap, however it is.
Right.
So that was put in there basically as a safeguard. If you do that, you treat the person as when they reach the age of 60, so you protect their pension. Okay, good.
Precisely, yeah. And section 84 generally deals with appointments by the public service commissions. Section 83 creates the public service commission, and 84 deals with appointments of public officers by the public service commission. And
So
then you have
it takes it away from the hands of the ministers and the prime minister and
Precisely.
the cabinet. Okay,
Right.
so it's like a buffer between the individual employee and the government.
and the government. So in other words, when you have elections, for example, and a new government takes power, then you can't just dismiss public officers because you don't have that power of dismissal across the board, especially that person is an appointee of the Public Service Commission. Public Service Commission responsible for appointing, disciplining, and terminating public officers. But you have all those others appointed on contract, and that's the next issue. Anyhow, we move to section 92, which is the key section. So with now Grenada attaining independence, I think the historical context is always important when we discuss pensions, like so many other things, because so you had a 1958 pension, and in those days the public service was relatively small. And in those days, you talk about Grenada being a colony of the United Kingdom, and in 1967 we had internal self-government. Grenada became an associated state of the United Kingdom with a premier, and then full independence in 1974. So section 92 protects pensions of public officers. So just put in a simple way, what section 92 says, listen, if at the time of independence you are working within the public service, then you are entitled to whatever pension rights existed at that time. So for example, if somebody joined the public service, let's say on the 5th of February, 1974, or the 20th of November, 1970, that person, that public officer will be entitled to a 1958 pension. And what section 92 basically says, at your point of entry, and you using the example of February 5th, for the next 26 years in the service, or until you reach the age of 60 years, you are entitled to a 1958 pension. The only how that can change is if there is a pension more favorable to you. It cannot be less favorable. So
Okay,
in that regard, Section 92 protected the existing pension rights of public officers.
okay. So in other words, let me just see if I could summarize it. You enter the service. When you enter the service, the law governing pensions is the 58 pension.
Right.
Yeah. When you retire, that is the pension you're entitled to.
That is the pension you're entitled to.
They cannot change. While they're working, they cannot change it and say when the law change, so you are entitled to a lesser pension. If they want to change it, there has to be something more favorable.
More favorable.
So that gives security. I enter the service at 18, yeah, and I know if I stay in the service for 42 years, when I leave, I will get the pension that is on the books now. When I enter.
And you actually know it.
Yeah.
Because you know how to calculate it, and these are formula to calculate it.
Okay.
So the 1958 pension.
So
yes.
it gives security of pension.
Yes. Yes.
Okay,
right. And
but
then go ahead.
But that was only for those who actually were entitled to pension.
Were entitled to pension. In other words, as it says, it protected existing pension rights.
Okay, brother.
Right, of the pension rights that existed at the time. And I say so because there are debates, in these issues, there are debates as to whether or not, for example, the pension has to be a non-contributory pension, or whether it can be a contributory pension. So there is that debate.
Right, but one of the contentions I've heard is that, listen, this quote-unquote 58 Pension Act that was in existence at the time the Constitution came into being, that in order it received constitutional protection. So that in order to change that act, some people say you have to have a referendum.
Right. So in other words,
yeah.
Well, the changes to make it less favorable, because the Constitution, and it's an entrenched section of the Constitution, if you have to change Section 92, as an entrenched section, you have to go by referendum. And ready to change it would be saying to make it less favorable.
But you say only as regards the people who are already in the service.
Already in the service. Right.
And there's the contention that, listen, to change that act at all, you have to go to a referendum. In other words, it is saying that somebody who is not yet in the service and joins the service 10 years from now, unless you have a referendum to change the 58 Pensions Act, when they enter the service, that is the act that has to apply to them. I know there's that argument and that thinking.
Well, yeah, but I would just say what are the views on it. Well, there's that view, and there is the other view, and really based on the interpretation of Section 92, is that what matters is what exists at the point of entry.
Right.
So, for example, and that's where the issue of NIS comes out. So, in April 1983, the NIS was established. In April 1983, and as we alluded to earlier, NIS was to take care of all pensions, manage all pensions. Because you can't have pensions depending on the consolidated fund in this day and age. If there's a hurricane the week before and the place mash up, then what happens in terms of the consolidated fund and pensions? So the idea is to protect it from early up. So essentially, the cutoff point, just as the cutoff point in this act, there's a cutoff point of 1st January under this new pension, public sector pension fund. There's a cutoff on the 1st of January 2025. Now, at that time, what it was said, listen, those who were there before April 4th, before the establishment of NIS, which took effect on April 4th, you get a 1958 pension. And once you come in April 4th onwards, you get an NIS pension. However, with respect to public officers, they will have a special pension under NIS, and that's pursuant to the power of the minister under Section 47 of the NIS Act. And Section 47 of the NIS Act, in fact, was the subject of judicial pronouncement and judicial comment in several of these pension cases. Whether it was the Irvin McQueen case, the Richard Duncan case, because the court said, listen, yes, there was an NIS, but what was intended by the PRG was not brought into fruition because it was never triggered. So, like, everybody kind of fell asleep on it. Until now, several years later, those people started to claim pensions. And then you had the Homeland Armstrong case and these kinds of cases. But essentially, what the Constitution is saying is that at the point of entry into the service, whatever pension that exists at your point of entry, that pension is protected by the Constitution. So now, if I could just, so those are the broad points from the constitutional standpoint. And the first, just by way of example, the first case that really dealt with pensions under the Constitution was the Donovan case in about 1990, after the retrenchment, the golden handshake retrenchment of the late 80s, 1988, under the Howard Blaze government. And what they said then is that, listen, if you we're retrenching, it was supposed to be the largest retrenchment up to then in the public service, and probably the largest up to now. And basically what they said, fear not, we're reorganizing the public service, and you will get a golden handshake. So basically your golden handshake will be based on your years of service. And Donovan challenged it, and he said, no, 84.8 says, if you're reorganizing, I have to be paid a pension as though I had reached the retirement age of 60. That's basically what the Donovan case said. And it's not based on what the Retrenchment Act, which was deemed unconstitutional, because it basically said those who are going home will get pension based on their years of service, right? So that's just an example. But in relation to the contract now, the contract employees, which again I know is a bone of contention for unions. But the issue with the contract employees really this: you have people in the public service who hold pensionable offices. We're not talking about non-pensionable offices because those people are not entitled to a pension. They hold pensionable posts within the public service. And what has happened is that these people have been put on contract, and the contract renewed over extensive periods of time. What happens there is if you put them on contract, they would not be entitled to a pension. So I have heard, for example, you had the Bihari case, where he was the sports youth and sports coordinator and so, and He was on contract. So he worked with the government for over 10 years, and he was sent home. He held a pensionable post within the public service, and therefore he's supposed to be entitled to a pension. However, he was placed on contract, and his contract was just being consistently renewed. And what the court held is that, listen, he was placed on contract. He was placed on contract, and therefore he was not appointed. He did not have a letter of appointment from the Public Service Commission, because these contracts, for example, are signed by permanent secretaries. And he's also, like in most of these contracts, they are subject to the Public Service rules and regulations of the Public Service Commission, which is still 1969 rules. So that case is under appeal, but essentially the distinction in that case was he did not have a Public Service Commission letter of appointment. Now the danger of that is this: if you can have a situation where a government now can circumvent the constitutional requirement and say, let's put everybody on contract, quite apart from the security of that person, security of tenure, you want to go in the bank, get a loan and these things, but you just had 2-year contracts being renewed. Nobody knows whether that contract would be renewed or not. What is happening, one, is the security of tenure of that person is affected, one. And secondly, you can basically hire and fire at your whims and fancies, which takes away the very purpose as to why the Public Service Commission was created. Because the Public Service Commission, as alluded to earlier, was created to act as a buffer between the politician and the individual public worker. So when you come in there, you can't just dismiss certain people in the public service because they are protected. Only the Public Service Commission can do so, especially with those who hold pensionable positions. So that's the issue with the contract. So, for example, if the BRE case is upheld on appeal, what it means is that those contract employees who are similarly placed would then be entitled to an 84-8 pension, because
if the appeal succeeds.
If the appeal succeeds, like in his case, and those who are similarly placed, because it would mean that you say, okay, you're going home. Now, government has the power to abolish positions and so, because that's part of the executive role of government. But all that is being said is that, listen, if that is the case, this is not a straight contract. The contract is subject to the Constitution. The contract, those kinds of contracts are subject to the Constitution.
And that's the standard practice of governments doing that. And apparently not only in Grenada, but in other islands.
Right, yes.
I may kind of have a question for Ruggles, because in my unlegal and unlearned position, it seems that the act literally disbands established positions. In particular with the case you just referred to, because the case you just referred to also ignores the issue that persons who are employed on contracts in permanent position, and in this case established positions, right, is unlawful, right? 29 says so. So, and I would want to quote a couple of people, 3 different people here. I want to quote one Deacon Mitchell. Put it Deacon Mitchell number one as a private sector lawyer who indicated in some arguments that I was part of that 29.5 is not broken if a worker stays on a contract for 16 years. This Deacon Mitchell number two, right? During the campaign for the 2022 elections indicated that what NNP was doing by having workers on contract in these positions is a breach of the law, right? And now Deacon Mitchell number three, right, who leads the government, has passed this law, which in some person's view literally disbands what we used to refer to as an established position. Because one of the major differences with established positions is that they could only be removed by the Public Service Commission and they were entitled to a pension. Right? Now, once government continues to employ persons in those positions on contract, that means they can be disbanded and they can be fired at will. And two, they're not entitled to a pension as we know it. And there is no question that a pension you paid for, that you're paying for, and a pension you don't pay for, there's no question which one is better, right? All the issues of affordability and so different questions that maybe people like Dr. Gilchrist and so may be able to consider. But strictly speaking, right? What this to me does is disband what we understand to be an established worker,
Okay.
an established public servant.
Okay. Rob, you wanted to say something on that?
Yeah, just briefly. Now, what the Act says, and see, this is why it's so important for information and education and engagement and consultation before, so that everybody can be clear. A lot of these discussions are now being held after the Act has been passed and put in place. You know, a lot of this should really be taking place before. But the Act, for example, describes itself as being applicable to all new public sector employees, right? All new public sector employees. 1, 2, then you have a different, so all new one. You enter the service in January 2025, this Act applies to you. 2, all public sector employees who hold non-pensionable offices by virtue of a relevant enactment. And the relevant enactment will be the police, prison related to pensions, teachers, etc. So those who hold non-pensionable offices will benefit. And all public sector employees who also have attained the age of 50 years, have neither attained the age of 50 years, so you're not yet 50, nor have you been employed with the government for a period exceeding 15 years. So if you're 50 and over, this Act and your whole if you're 50 and over, or you have been working with government for a period exceeding 15 years, and you're not eligible to receive a pension, gratuity, or other allowance, in accordance with the relevant enactment, this Act does not apply to you. And then now, I think the C, under C, it says all employees who are currently employed in the public service on a contractual basis. Now, so the issue is, and there are certain constitutional challenges pending in relation to that, preceding this Act. whether or not those who are in the service currently, who have been just, whose contracts have been renewed just consistently, and whether or not you're not really a permanent employee. No, but your reference to section 29.5, that's not a reference to the Constitution. 29.5 refers to the Employment Act.
I understand that.
Right? Employment Act, and basically the essence of 29.5 is that if you are even if you are employed on a contract, on a fixed term contract, but the nature of the work that you do is so inherently connected with the operation, with where you're working, and is of a lasting nature,
In
you'll
an
be
established
deemed,
position. In an
right? You'll be
established
deemed.
position.
Well, because that applies to the private sector.
No, I understand
Private
that.
sector. Remember,
But in the
public
case we
service.
speaking to,
Sorry.
in the case we speaking to, which is
Ah,
the public service, in particular, it applies to. So you can't say that someone is a contracted worker, right? One doing work and is in an established position of the public. So the person is a public servant. The contracts have been renewed over and over, which is I understand that 29.5 is not the Constitution, but based on even the
on the
way the
Employment
law,
Act. Yes, yes,
that is an illegal act. So when the government employs you and continues renew your contract for 16 years, right?
yes,
That itself is an illegal act.
yes.
So
Because, well, yes, that's 29.5 is in the Employment Act. And what the Employment Act is really sets out certain minimum conditions. So you have the public service and you have the public service regulation. Regrettably, since 1969, more than 50 years now, you have those same regulations that have not changed. But the Employment Act applies generally to workers across the board. But of course, it's persuasive in terms of arguing that, listen, even in the public service, you can't have somebody just on never-ending contract.
that's the point.
Yes, because it then becomes like a permanent position. Yeah. So I just wanted to make those distinctions there, because so all new people entering the public service, all new public sector employees, and public sector employees are defined are not just confined to the government, but also relating to statutory bodies. So new public service employee means a public officer, a teacher, a police officer, a prison officer, or an employee of a statutory authority body. Right? And that's why my good friend Curlan, these two schemes, when I say these two pension funds can create some issues
Yeah.
there.
Well,
Yeah.
we almost running out of time, but I think I have a discretion to extend this a bit because I want to, at a minimum, invite a call or a few calls. The number is there. If anybody can call and we just have a comment or a question.
While you are waiting on the caller, I just
Yes.
want to ask you, Ruggles, so if you are that part about the 15 years, those persons would get an ex gratia payment, right? And that's a different, that's why you have that there.
But that is
Okay.
protected by statute, Curlan?
Huh?
Is that
Yeah.
protected? Is that payment protected?
It's an agreement and a practice. I don't think there's a lot to it, but yeah, those not it's a small group of people, right? That would would get what you call it's about $500 or so. All right, so I think that's why it doesn't cover them. They're needing to get a special payment. But I just want to ask Ruggles a question though.
Mm.
If you are a contract and you are carrying out duties of a pensionable post, yeah. Um, does that mean that how is that different from a pensionable position? Because what happened is I can put you on contract, but your duties involve duties of a pensionable position, right? But it doesn't mean that you are holding a pensionable post. You are just carrying out some of the duties of a pensionable post.
No, you see,
Okay,
that's
so
why.
we have a call.
Sorry, I'll come back to that, Curlan.
We have a call. Scholar, you are live.
Yes. Good
Yes.
evening, everyone. Chester Humphrey here. I wish to join the program to ask a number of questions and to make a very short observation on a critical issue, which seemed to be one of the tracks upon which the formulation of this new pension for so-called public officers on recurrent definitive term contracts seem to lie. Dr. Gilchrist more than suggests to the listening public that the NIS is befriended with a series of insolvency issues. And in order to safeguard and to protect the NIS in its states of in various states terms, so no, we are at a loss as to find out precisely what he's talking about. Because the solvency or insolvency issues facing the NIS is precisely because not of the NIS in itself, but it's precisely because of the conduct of the executive of the country at various times. All of the political parties, save and except the PRG, are guilty of this. They have, for narrow political reasons, refused to comply with the recommendations made by actuaries to do the timely adjustments so that the fund can be stabilized. And I noticed that, as I said, Dr. Chris, well, I won't want to describe it as skillfully, stayed away from giving any indication of what were the unsettling matters related to the solvency issues. But I can safely tell him, and Comrade Paterson is there, and Comrade Paterson has the advantage of being sitting on the NIS board of directors for many years. So he has the institutional knowledge to support what I am putting forward as the main factor in creating whatever instability to which Dr. Gilchrist refers. And that plays right into the questions raised by our king sponsor. Sorry for the colonial term, but it's really one of distinction and not so much one of colonial privilege.
Okay.
And that is under this construct of this so-called pension arrangement, it has absolutely no protection from the vagaries of the executive, who is prone to interfere with these things in a manner which makes them financially very vulnerable. I say no more on that. That's just a comment on that.
Okay. Thank you.
My question is really directed to the question now is directed to Brother Paterson. I cannot for the likes of me understand why the unions have failed to go to a court of law for a declaration in respect to the widespread abuse of 29(5) of the Employment Act, where the public sector unions are the ones most directly involved in this matter here and should be the ones in the forefront of this. All of these contracts that are given, especially for posts that are permanent posts, posts for which there is a budget in the annual constitution, right? And for which there is a designation in the budget. All of these persons there, Bihari fits the bill, and Mr. Ferguson speaks about Bihari, fits the bill of a permanent post where they are issued contracts of a definitive term purporting to be contracts of a definitive term when Section 29.5 addresses that question, right? Why is it that none of the trade unions have gone to a court of law for clarity on that question?
Okay, thank you
To me,
very much, Colin.
this is the heart of the issue that we are currently discussing insofar as this pension thing is concerned.
Okay.
Because if that question is addressed, then everything else falls in place. And I believe they are very powerful arguments. And we have two attorneys, both the host and Mr. Ferguson, who I have no doubt will be very sympathetic to the arguments that 29.5 is applicable, certainly in the case of Bihari, all of the other cases.
Okay, Colin. So I will have Mr. Ferguson, Mr. Paterson answer you on that. Thanks very much for the call.
On the second matter, and even in more important issues, because that is a matter that has been argued a lot of times, and it has never gotten to the courts, all right? Because in most cases, outside of in dealing with the government of Grenada, we've successfully argued and gotten through without going to court on that matter. The only area we have not succeeded in doing so is with the government of Grenada. And I'm saying not one government, not this government, but all the governments. In fact, the reason this contract work came into being was, in fact, to try to get rid of the unions. And I can say that without any hesitation. And which is why, as Ruggles said, 84 was put into the Constitution and 82 was put into the Constitution because the performance of the GLP government at the time, sending persons home, sending persons in Carriacou, etc., etc. So that is the reason why that unique thing was put into the Constitution to protect workers.
Yeah,
so,
sorry. I must say, in all fairness, I know there have been studies done in the Caribbean which indicate that across the region, governments, starting with the government in Jamaica, Trinidad, they have all felt the need to, I'm trying to choose the words carefully. All these governments in the region, they felt that the public service regulations and the public service system handed down to us by the British and the protection given to employees. All these governments across the region, and there's actually a study on that, felt like that was hamstringing them in terms of getting their work done. You can have whatever view you want on it. So they created this if you want to call it a strategy of having these special arrangements, these special contracts. We call it at one time, I think we call it Vote 340 in Grenada or something like that. But you had the equivalent in almost all the Caribbean islands that got independence before us.
And none for efficiency.
And well, sorry.
And that has been proven. None for efficiency.
They all claim it was to enable these governments to get their programs, because they went to elections, they came in with a program, right? And they all claim that in order to be able to implement their programs and implement what they had in their manifesto, they felt sometimes they were not getting the cooperation from the public servants. They couldn't move them, they couldn't do this, they couldn't do that. of course, we need balances in the society. And I think that has been part of the problem. So I think it is something that goes beyond Grenada. In Grenada, the fear was, in the circumstances of independence in 74, that not only you will have like what you have in Trinidad and so, but there might have been spite and malice and so on. And it was to guard against that. And you know the circumstances in which we got independence.
I understand that, and let me just observe that my brother Donald Trump is talking about doing the same thing now, getting rid of all the public servants to get his people in place, and it is never.
And it's the same argument that is being made.
Never for efficiency, but let me just go back to Chester's point, and to say that one of the reasons actually that we saw this legislation rush through, and we thought it was not a priority issue without consultation, without negotiations, to go forward with it, because there are other legislations which addresses one of the matters Chester raises, that right now we're not sure if we can even go to court on 29.5, because the ruling of the Privy Council does indicate that everyone in Grenada has a right to go to court, which is something that the present government is much aware of through the Labour Advisory Board and public statements, that we are now not even sure if we can go to court on those matters, because the only persons in the island now who do not have the right to go to court is a worker. And that, whereas it would have been possible prior to those rulings, and as I said, the matter did not go to court, because in most places we were successful in correcting that. The only place we have not been successful already is the government. So actually, the government is the biggest breaker of the law in Grenada. Sad to say, but that's the case.
Okay, so folks, I'm kind of sorry we have not really exhausted this, but we need to wrap up for tonight. Brother Simeon Collins, my co-host, I must tell you have a very strong advocate here who is saying that I'm not allowing you to say anything. So I will invite your closing comments firstly.
Very interesting stuff. More or less, I used to work with a statutory body, the Grenada Bureau of Standards. I'm happy to hear now that under the new legislation, they will be catered for. The second comment I want to make is that I used to be on the board of directors of the NIS. So I was the deputy chairman for a few months, and I know there are about four union people there. Two representing the union, I think, one the Employers Federation, and of course the union representative of the workers of the NIS. So I wanted to know whether these union representatives more or less were aware of this new land and just give it a blind eye, as as it's been voiced here. Couldn't they, at least when it reached their meeting, couldn't they at least stand up and take a decision on that? These are the two major things, and I must say that everyone gave us a lot of food for thought. Because I am amazed. That was very good, I think. I took a lot of notes. I'm going to be reviewing it a lot now. It have cleared me up. But Layne again, very good, very nice. And Mr. Paterson, you have really represented the union. As usual, I met you on NS, I met you in the Fisheries Board, I met you. How I met you? I think you have always changed my position, in favor of the workers. When I took a hard line when I was, in fact, at the chair in the board. So keep it up. Good work. Thank you very much.
We have Dr. Gilchrist also, Asilia.
Yeah, Curlan is my partner, man, since 2000.
Okay. All right.
He really is good as a statistician. He is very good. The actuarial position, and so I was well explained, and I know he defend himself. He defend himself very good.
No. Just one correction. You know, I hear not in my personal capacity. Since I chair the committee for the government,
Yeah, I
I am
understand.
constrained to
Yeah,
Yes, I understood.
government.
We are aware of that.
Yeah, right.
So,
So I'm in alignment, right?
yes.
Yeah.
So, Colin, let's have your final comments.
Yes. Yeah. So I just want to say that I it's unfortunate that a lot of the debate is taking place now, and I want to take it from where Ruggles left off. It's unfortunate, but we did attempt. Maybe we should have done more. Attempt to engage a lot, the union and other stakeholders. We have had a lot. Um, so I take that point, but I think all is not lost. There's always room to make amendments to the law
Mhm.
and go forward. And as this new law kicks in, and we see the potholes and the areas that shall come in, I'm sure the government would be amenable to amendment. But the essence of the law really is to provide some kind of benefit to those 4,000 workers who are not under the 1958 pension. I think that's the essence of it. So, and I just want to say in closing too that it's a development issue. It's a development issue. Wealth is being created. How you share and distribute the wealth among the population, the equity issues. So I heard one former prime minister did speak to the public workers and union who want the whole cake. They want to eat everything. They don't want to share. You know. But this is an attempt to spread the benefits of our labor across all sections of the population. So let's give it a shot. Let's try. And I believe that with the position being raised, I think we can solve those problems. We can make the changes and have a pension plan that is applicable and makes sense. Well, let me just say in closing too that the 3% is small. Yeah, it's not much money, but for those, and this is a plus of the new pension scheme, for those who have been on contract for a lot of years, the government is giving them a credit, right?
Yeah.
For those years, and so they're not starting from zero, right? They're not starting from zero, but I take the point also from both the management is important, the management of that fund, because investment involves risk. And once you have risk, you know what happens. Can go up, can go down. Right? So the management is important. So let's see what happens. And I think collectively we could ensure that the fund evolve into something that will be beneficial to the population.
Yeah. Okay. But
All right, I'll use my closing comments just probably to point out because the time really wasn't enough. We couldn't even delve into the matter, into all half of the matters that we had we would like to identify. But I'll just deal with this one as in my closing comment that the act calls for the phase vesting of contributions. All right. That is the monies that are paid into the fund on behalf of workers, even in the private sector. In the past, sometimes you had to wait 10 years for that money to become yours. In this case, which is a government pension, which workers are paying into, right? It takes a good amount of years for the contributions to be vested in the person. And I think that is absolutely wrong. In fact, in my own view, that even Garfin should be complaining about that. Once an employer puts money aside for a person, that should belong to the person. And as I said, we had that in a lot of the private and private sector firms on this vesting matter, and most have agreed to remove it from these insurance managed pensions. Whereas once money is put aside for a worker, it should belong to the worker. But in this case, I was really shocked and surprised to see that it is not vested in you until a certain minute. So meaning government could take it back if you dismissed or you leave the job, etc., which I believe is really improper. and probably against some parts of the Insurance Act and GAFIN rules and regulations. Other than that, I would just like to say that I do share the view of Ruggles and the caller that it would have been more practical, efficient, and more controlled had NIS been given an opportunity to be involved in, because you just have a duplication of services now, and it will be an extremely expensive duplication. Hopefully, the persons who have gone ahead and put this into the law, I know that once things go into the law, it's very difficult to amend it. I must say that the Employment Act has really been amended in the past, 30 years, since 1999 to now. And it may, but I would just like to ask, and maybe through Mr. Gilchrist, that let them have a look and have some discussions, late as it is, on certain parts of this act that definitely could jeopardize the funds of the workers. Thank you for having me on the program.
Thank you. Ross?
Yes. Just to say in closing, lots to say, but I take it one of the positives of the act. It addresses persons who hold non-pensionable offices. That's an aspect of it, and it's certainly a positive aspect of it. But it also goes beyond that, because remember, this is essentially the new Pensions Act. It applies to all new public service employees. And all new public service employees, as defined in the interpretation section of the Act, deal with all new persons in the police officers, prison officers. And it says in the short, new public sector employee means a person who is appointed as a public officer, a teacher, a police officer, a prison officer, or an employee of a statutory body. So it's not restricted. It's not an act that is restricted to, as I understand it here, subject to correction, but it is the new act that governs pensions for everybody who enters the public service, whether an established or non-established employee, as of 1st January 2025. So the aspect of a non-established employee getting pension, that is great. But we have to be clear, and Curlan can clarify that. Isn't it in the act? In fact, let me just probably ask co-host if does it not apply to all public officers entering the service, as you understand it, Curlan, from the first?
Yes, you are totally correct. That's the act. Yes. That would be in effect. Anybody joining thereafter would apply, whether you permanent.
Right. Right.
You are totally correct.
Yes. So, but what I'm hearing in terms of the public discourse, is that it is for non-established workers, that you have an act for non-established workers and they will get a pension, and great. However, I think it needs to be clear that this is an act that applies to all public. Once it's like what was done in '83, which says, listen, NIS applied 1958 pension up to 3rd April when you enter the service of the 3rd April 1983. NIS pension from 5th April 1983 or 4th April. In this case, as of 1st January 2025, once you enter the public service, whether permanent, temporary, well, not temporary, but established or unestablished, you get a pension in accordance to what this act says.
That's correct.
Okay, thank you. So I just, in terms of my comment, is that there needs to be, and in my view, there should have been much more discourse and sharing of information on it before the passage, but it's never too late. It's already passed, but I think the unions and other stakeholders need to engage and understand the act in very clear terms, so one understands what happens moving forward as of 1st January 2025.
Yeah. For me, I think that the act and the purpose and the spirit of it is quite commendable. In my view, it seeks to address a problem that is well over 40 years old. In fact, it's a problem that goes back to 1983. What has happened now, in fact, is that the difference between now and 1983, as I see it, is that you have the ending of one system, and immediately a new system is put in place. The new system being the new act. So persons entering the public service from the 1st of January, they are not entitled to 1958, but there is something for them. In 83, it was said you're not entitled to 1958, but there was nothing in place. And that remains so for over 40 years, as we all know. But of course, there are clearly weaknesses in the act, and I think Bert has really highlighted some. The issue as to whether you have a new structure or you deal with the NIS is really a policy issue. And I don't know all the considerations. So while there are clearly, in my view, compelling arguments to have gone with NIS, I'm not clear on what are the policy reasons that the government chose to set up a completely different structure. So it would have been good to have more discussion on that, but I can't say I have a certain view and a certain position on that. But like with everything, I hope with the regulations, and I hope that the government is open to revisiting this, because there's no doubt in my mind that it's a good initiative. I was always disturbed by the view that many times taken that public officers are entitled to a constitutional pension, and that was always being said, not recognizing that there are a whole class of public officers described as non-established who never had a pension, other than the NIS pension. And in fact, before NIS, there was nothing for them. So I think that this seeks to redress it. And as Dr. Gilchrist says, this is about development too, because we have a situation now which we did not really address tonight, you have a whole set of people who are, in fact, because of the decisions of the court, they are receiving, in some cases, 120% of their last salary. I don't know any country could really sustain that, and I think there will be a problem when young people realize that, in fact, they are the ones who are paying that, and they could never get the same. Obviously, they could never get the same because that will sink the country. So I think it's really about dealing with and addressing our history, and in the best way we could, in the most equitable way we could. But so that's why I really commend the initiative to have this pension scheme, but maybe there are issues in terms of the implementation much more discussion, much more participation, I think would have been helpful. I really want to thank again all the Ruggles, you, Bert, Curlan, and of course my co-hosts, and all those who have been following. I hope in the future we have more calls, and of course, before we end, I just want to thank the sponsors again, Gel Professional Solutions, JBFM out of Canada, and also Grenada Technical and Allied Workers Union. We have the president here, the general secretary here tonight, but I just want to thank them for assisting in this program.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, thank
Good
you.
night,
Next week,
everyone.
yes, next week we'll be back, and next week program will be on crime and the issue of crime and efforts to neutralize the issues of crime in Grenada and in the Caribbean, including Trinidad and St. Vincent. Thank you very much, and good night, everyone.
Yes, thank you. Thank you.
Yes. Okay.
Good night, everyone.